Just, I mean, I've heard about this just briefly, and
Okay.
wait until right here gets back.
Motion in limine you're referring to?
Yes, Your Honor.
Okay, hold down. Just a second.
Judge, actually, this is motion limiting. We didn't put a number on it because I think in previous rulings, or not rulings, filings, it may have been number 13 or something like that. I thought it would be probably easier just to do it over again. And this is just the unringing the bell type motion dealing with matters that are...
It's just going to take a minute, all right?
Certainly. Okay, it's close. That certainly matters that need not be addressed, but out of an abundance of caution, and a motion in limine is just that. Saying, before you go into this, advise the court and have a jury out hearing. And one reason we file this is that, as the court knows, Wednesday in Chattanooga, I think one of the first things that Mr. Reagan stood up and told the jury was to point out that his family is here, his brothers, and we think that is, totally inappropriate, and that would not be, as the instruction the court will give, there to be no sympathy, no prejudice, and that information necessary to introduce the defendant is all that is necessary. And going beyond that, about his family's in the courtroom, their presence, that they're sitting over here, all of that sort of thing is really not relevant to the proceedings that we're having here today, and would ask that not be allowed. The same thing, the hostess program, I think, and certainly these counsel weren't there, but in the Batey trial, one of the first questions to one of the first witnesses was for something to the effect of, were you part of the hostess program? Well, we know it didn't exist, no such thing. So before it gets...
part of a hostess program, as well as other football players obtaining hostess.
And Judge, I object to him interrupting me before I finish. He gets a turn. The jury's not in here.
If he's not going to cite the right facts, then he needs...
I would ask that he be allowed.
Stop right now. All right. That's right. Have a seat, Mr. Perez. Let the state go, then you will have your opportunity. All right.
Again, back to what a motion in limine is. Just saying that before we go into that. Existed. So that is the standpoint. Counsel, the only thing that we're dealing with right now is that he not go into asking, or whoever is questioning the witnesses, asking about it as if it did exist without having a jury out hearing. I don't think that's too much to ask. And again, apologize for being upset about this, but it is upsetting to be interrupted and accused of not stating the facts when the court has been here and has heard all of the proof about this matter. And the same certainly goes with anything that would delve into any aspect of touching on the court's Rule 412 motion. Not here asking the court to disallow it, but that before something is said, that the bell can't be unrung, that we have a jury out hearing. No more, no less.
All right, thank you. All right, defense.
Thank you. As far as evidence or statements beyond that necessary to introduce the defendant to the jury, I would imagine his name, his age, where he's from, that sort of thing would be appropriate.
I don't think the state has raised any concerns with respect to that.
That's correct, sir.
Well, in the strict reading of their motion, anything beyond his name would be inappropriate in introducing him to the jury. I just want to make sure of the parameters of what we're allowed to do. And as far as any evidence or statements relating to the defense family, the presence in the courtroom, or any other irrelevant information, what irrelevant information are we talking about?
I think at some point about perhaps his younger brothers having some medical issue, seeing somewhere in mind that there was something brought up about matters totally unrelated to his guilt or innocence in this matter. And the background information.
Well, Judge, I think it's important for the jury to know that this man is a human being. He does have a family that supports him.
Right, I think the jury would understand that. That all of us are human beings, and we all have families, and our families support us, I suppose. But to get into matters that are not relevant is something that either side can object to.
And with regard to the existence of the hostess program, there is evidence in the record that Coach Franklin did ask Ms. Lackey at one point in time to participate in a hostess program. I do not intend to use the word hostess program. At least Ms. Martell and maybe others worked for the football officers and that they did assist in recruiting. And also, DeAndre Woods, in his testimony, used the term hostess program.
Well, I think the state's proposition was that we would have to have a jury out if that issue arose, and we would do so.
Very well.
And also with respect to any 412 issues.
Yes, sir.
Anything further?
Judge, if I may just, again, Mr. Fuller and I were not at the 412 hearing that was held before we came into the case. I know that 412 deals with instances of sexual behavior or sexual conduct by the alleged victim. We do have evidence that they had
Yeah, you know.
and I object to his statement, this kind of stuff. All I'm doing is talking to the judge.
Gentlemen,
How do you know what I was about to say?
Mr. Reagan,
Yes, Your Honor.
that's an issue we dealt with in chambers for sound reasons. And if we raise those kinds of issues, we will have to do so in chambers, all right?
Maybe do so, are you talking about right now?
Well, I don't think we need to do that right now. Again, this is something that the state raised and said, whether if some issue comes up, we will have a jury out hearing, and in this particular case, if it's regarding 412, we will have it in chambers. So it's just simple as that.
Well, Your Honor, can we have a brief in chambers then before opening statement? So that I know, I don't want to violate any court orders with opening statement.
Well, okay, well, I'll need to send the jury back down the hall for a minute before we can do that. And I'll grant you that. We can do so. If we can start this trial before next year, I will be happy.
Yes, Your Honor, I would be too.
It's always weird when we do it.
All rise.
All right, everyone except the jury, please be seated. Morning, ladies and gentlemen. I know what that means. Welcome to Nashville, by the way. We're going to get started right away, and the way that we get started is I need all of you to please raise your right hands.
Do you swear or affirm that you will well and truly try the issues joined in a true verdict rendered according to the law and evidence, so help you God?
All right, please be seated. All right, we will start off by the reading of the indictment.
For the record, it does look like the same folks we saw in Memphis.
It does.
Members of the jury, the indictment in this case reads as follows. State of Tennessee, Davidson County, count 1. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie on the 23rd day of June, 2013 in Davidson County, Tennessee, and before the finding of this indictment, did intentionally, knowingly, or recklessly engage in unlawful sexual penetration Jaborian Deshaun McKenzie did aid or abet each other in the commission of the offense, and Brandon E. Banks, Cory (9-13-502) and against the peace and dignity of the state of Tennessee. Count 2. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie on the 23rd day of June, 2013, in Davidson County, Tennessee, and before the finding of this indictment, did intentionally, knowingly, or recklessly engage in unlawful Robert Vandenburg and Jaborian Deshaun McKenzie did aid or abet each other in the commission of the offense, excuse me, and Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie knew violation of Tennessee Code Annotated Section 39-13-502 and against the peace and dignity of the state of Tennessee. Count 3. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie on the 23rd day of June, 2013, in Davidson County, Tennessee, and before the finding of this indictment, did intentionally, knowingly, or 'Kenzie did aid or abet each other in the commission of the offense, and Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie knew or had reason to know that Elizabeth (502) and against the peace and dignity of the state of Tennessee. Count 4. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie on the 23rd day of June, 2013 in Davidson County, Tennessee, and before the finding of this indictment, did intentionally, knowingly, or recklessly knew or had reason to know that Elizabeth peace and dignity of the state of Tennessee. Count 6. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie on the 23rd day of June 2013 in Davidson County, Tennessee, and before the finding of this indictment, did intentionally engage in Robert Vandenburg and Jaborian Deshaun McKenzie did aid or abet each other in the commission of the offense, and Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie knew or had reason 39-13-504 and against the peace and dignity of the state of Tennessee. Count 7. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Brandon E. Banks, Cory Batey, Brandon Robert Vandenburg, and Jaborian Deshaun McKenzie on the 23rd day of June 2013 in Davidson County, Tennessee, and before the finding of this indictment, did intentionally and against the peace and dignity of the state of Tennessee, and it is signed by Glenn R. Funk, District Attorney General of the 20th Judicial District, and filed with the Clerk of the Criminal Court of Davidson County.
All right, Mr. Vandenburg, if you would please stand. In the case of State of Tennessee versus Brandon Robert Vandenburg, docket number 2015 C-1517, what is your plea to the charges of aggravated rape, aggravated sexual battery, and unlawful photography?
Good morning, Your Honor. Not guilty.
All right, thank you. You may be seated. All right, we will now move to opening statements.
Your Honor, please, before you approach.
Well, back in the back. and gentlemen, I'm going to have to take up some issues with the attorneys. I'm going to have you to step back. I hope that you're well taken care of while you're back there, and I'm sure you are. So if you would please step back in the back.
All right.
All right, please be seated. All right, I see that the defense has filed a motion to dismiss pursuant to prohibition against double jeopardy. I see it for the first time just a moment ago, and the defense wants to make an argument, and I will allow the argument. Go right ahead.
Please allow me 1 second. Please stand up, please, John.
John, will the laptop presentation work on your computer from this?
Supposed to work. Now, I can't be definitive in saying that it will work. You have that thing that
Your Honor, please, I'm going to pass up. This is the presentation hard copy. I'll give a copy to the state. Should the court wish to follow along. Your Honor, please, I've got that up on my... It's not showing on my screen. I don't know if it's showing on your Honor's screen.
not showing on my screen. We have requested our IT guy to come in to help us out.
It's recognizing it's just not working at all.
Go back and see if Mark is on his way over here.
Should come up,
Somebody is not clear. Okay, it's up now.
Okay, it just takes a minute to warm.
It's up. Would you let them know in the back that, well, it was up?
Just disappeared again, Your Honor.
But we still need it. It's up again, but there's no guarantee.
Now it's back up and it disappeared again.
When we do take a break, we need to take that clock down. Okay. Let's just... Okay.
Good. It should stay on.
It's on right now.
Well, I'm not going to touch anything, Judge. We'll see if it stays up. There may be another HDMI cable, maybe this one's got a short in it.
Should be neutral.
Should be. Let's try it.
Well, when it's ready, I'll be back.
Send the text.
Yes, sir.